And so often, right, the renter simply wants a safe, habitable place for themselves and their family to live. And I guarantee you that every owner wants a safe, habitable, up-to-code place to rent out and to make some money from.
How prepared are you to navigate the latest legal challenges around evictions, fair housing, property condition claims, or manufactured home disputes? However you answered, you are in the right place. Today, we're diving into the complex and evolving world of landlord-tenant law. Whether you represent landlords, tenants, or both, the stakes can be high. Hi, I'm Peter Kramer, Digital Communications Coordinator at the State Bar of Wisconsin, and I'm privileged to be joined by two esteemed attorneys in this space, and who will be sharing their insights at the upcoming State Bar of Wisconsin Pinnacle Seminar, Landlord-Tenant Update 2025. Professor Mitch is a clinical professor at the University of Wisconsin Law School and director of the Neighborhood Law Clinic, which provides legal representation and advocacy services to people in the community. He is also a founder of the nonprofit law firm Community Justice Incorporated in Madison that provides direct legal services to low-income individuals. Mitch brings a wealth of experience representing tenants. Next, we have Jessica M. Kramer, the managing partner of Kramer, Elkins Watt, LLC in Madison. Jessica's practice focuses primarily on representing landlords, especially manufactured housing communities, sometimes called mobile home parks, across the state of Wisconsin. She brings practical insights for attorneys representing landlords in this often overlooked but critical area of law. Together, Mitch and Jessica will offer their unique perspectives on the most pressing issues in landlord-tenant law today. Their expertise will help you better advocate for your clients, whether you're navigating a contentious eviction hearing, handling a fair housing complaint, or crafting a solid rental agreement. Whether you're a new lawyer seeking foundational knowledge or an experienced practitioner looking for fresh strategies, this conversation will be valuable. So let's jump in. Thank you both for being here.
Thank you for having us.
So, broadly speaking, I just wanted to ask, and I'll kind of shift back and forth between the two of you, but how did you get into this area of law in the first place? Mitch, maybe it would be okay to start with you.
Yeah, so I was renting an apartment when I was in college, and I woke up with a couple of inches of water on my floor because pipes in my ceiling had burst. And so I had to take a crash course in what my rights as a renter were. And that sort of started me off on wanting to learn more about renters' rights. And that continued, luckily, through law school and then into practice. It's an area that impacts so many people, whether you're renting or owning property. And it's so essential, right? Because everyone needs a place to live. So I find it really rewarding to be able to help out both renters and owners come to agreements and understandings rather than when bad situations come up.
Wow. Okay. And just water is the worst.
It wasn't clean water.
Oh, ouch. Definitely a learning crash course there, I can imagine. Jessica, what about you? How did you get into this area of law?
Yeah, excellent question, Peter. I don't think many people go to law school saying they want to be a landlord-tenant lawyer. And I, for one, didn't have any courses that touched on it. I don't know if Mitch did. We were classmates, by the way, same small group. So after I'd been practicing about 7 or 8 years, and I was mostly doing litigation, so I was in court all the time. An attorney from another part of the state, I'm in Dane County, had asked if I could handle some court appearances for him and a client of his as local counsel. And I said, sure, I'm comfortable in Dane County court. And they happened to be eviction cases. And so I started learning about the eviction process and landlord-tenant law just by being local counsel. And then that sort of evolved. I was like, oh, this is interesting. I could handle this. And it was in the manufactured housing community space. So I slowly handled more and more. And then I started becoming known in that space. It's a very niche area. And as it turns out, there are very few attorneys that deal with manufactured housing communities. So it quickly became my primary practice area because there was a need for people to represent them.
Yeah, That's fascinating. That is, I would say that is not something I had ever really considered, but obviously there is a need out there for that. Well, that's two very unique stories, and we're thrilled to have you both. So you're both going to be speaking at the upcoming landlord-tenant law update in a couple of weeks. And I guess what I wanted to start with, and Jessica, maybe we'll start with you, is what's the kind of what do you want to bring to that session? What are you hoping attorneys will take away from you?
My hope is that this update will be valuable both for experienced landlord-tenant practitioners and attorneys who are either thinking about getting into that area, or perhaps more significantly, attorneys whose core practice areas are something else, but they end up having landlord-tenant issues cross their desk from time to time, such as real estate attorneys, business attorneys, maybe attorneys that do some consumer protection work. Oftentimes there are landlord-tenant matters that pop up because everybody, as Mitch said, almost everybody is or has been a tenant at some point, and many people have tenants. So it's good for attorneys to have a general overview. So even though this is framed as an update, there are going to be some 101 elements to it. So I wouldn't want attorneys to think, well, I never even took one landlord-tenant seminar, so I shouldn't take the update, because it should provide information for people from a wide array of experience levels.
That's great to hear. Yeah, it's definitely one of those things where sometimes you just don't know coming in. Is this session for me? Am I a beginner? Am I intermediate? So it's great to have a little bit of both, and then they can ask their questions when they're there. Mitch, what for you? What are you kind of hoping that attendees will take away from you? What are you planning on bringing to the session?
Well, man, Peter, we've got such a great lineup of presenters. Jessica and I are just lucky enough to be two of them that are presenting. And honestly, I'm looking to learn. As Jessica said, there's going to be some basic information, but there's information that's different in every county that you practice in. And every situation has a lot of unique aspects to it. And so I'm always fascinated by this area of law, because it's very much unique to individual situations. Just, if you've ever shopped for an apartment or a home, they're always different. They're so, like the location is different, the amenities are different, your experience there is different. And that is true with rental housing, and it is true with rental housing problems, and it is true with rental housing courts and rental housing solutions. So there's always more stuff to learn. I'm excited to present, I'm honored to present, and I'm excited to attend.
Wonderful. Well, we're thrilled to have you both. So, Mitch, I was going to ask you then, how do you think the upcoming seminar will highlight some of the most important things for attorneys in this area of practice, especially considering tenants, I guess?
I think by going over again, the basics are key. But then there's also been a lot of developments, and I think that's why one of the reasons where we framed this as an update. So there's been a decent number of changes. Certainly there were a lot of law changes in the 20 teens. A lot of those changes continued up until about 2017 or so. 18 and then there's been rental assistance following COVID. There's been recent litigation that we're going to discuss a whole lot that from some published case law. So we're going to be talking a lot about all of those updates in addition to the foundational information. That's just going to be a good review for folks that know it and a great intro for folks that don't.
Yeah, that's wonderful. And Jessica, from more the landlord side, what do you think that the seminar will highlight for attorneys coming into this area of practice?
Well, from the landlord side, as is often the case with the party that is more likely to be sued, if you will, and the party that sort of comes to the relationship with maybe a little bit more power, for lack of a better word, is prevention and protection and compliance, to make sure that they are understanding tenants' rights and following all of the laws that govern the relationship, and avoid getting sued and getting hauled into court. And if they do need to pursue their own rights, such as an eviction action, dotting all their I's and crossing all their T's, and doing it in compliance with all of the laws.
Well, that's a great segue, because what I was going to ask you next is, what do you think are some of the more common mistakes that attorneys make when they're advising landlords?
I would say this is probably true with many practice areas, but approaching it without the appropriate depth of knowledge or research can be very risky. And often approaching a residential lease like it's any other contract is a giant mistake. There are a number of regulations that apply to it. The Department of Agriculture, Trade, and Consumer Protection, has some regulations that deal with the landlord-tenant relationship, as well as some statutes. And so I see, both from other attorneys who don't practice in this area and from pro se landlords, that if they're drafting a lease, or even if they had an attorney draft their lease for them and they're just trying to enforce it, they don't realize that there are some very specific things that apply. For example, you have an attorney fee shifting provision in your lease and it's void. You may as well throw it in the trash. And if you approach it like it's any other contract, you might miss that, because in most contracts, you can have a fee shifting provision. So that's just one of many examples. And it's often something that, if you're either not an attorney or you're an attorney that doesn't have experience in this area, you just don't realize that.
And Mitch, I kind of turning to the same question to you then, is there common mistakes that you see attorneys make when they're advising a tenant?
Yeah, to echo what Jessica said, there's a lot of unintuitive things about the law. And as Jessica explained, that folks are not going to be aware of, and really that's why you attend, that's why you learn the law. It's really important. I think I think actually a specific one that I don't mind repeating, so I may say this a few times, and that is that communication is something that I don't think people put enough emphasis on. The rental housing relationship is an ongoing relationship. Like you have a renter, you have someone that you pay your rent to, and that is a continuous relationship. It isn't a boom, somebody hit me on an auto accident, or somebody did something in this one incident. And so, or I'm going to make a contract, but then the parties in between the contract are completely different who carry it out. It's very personal, and it's very ongoing. And so the need for communication and open communication is something that I see people on all sides of the rental housing situation underemphasize and underutilize, really. A lot of times we just get people to communicate when they get to court, and that's frankly too late.
That's a great point. Well, I know this session is going to cover a lot of ground. So I wanted to dive into just a couple of those areas between the two of you. And so this one has more to do with sort of evictions and sort of initial proceedings. Jessica, I was going to ask you, what are some of the most common pitfalls that landlords encounter during that eviction process that you might be covering in this upcoming session?
Yeah, we often find in representing landlords, we have many clients who either typically handle evictions themselves, or they've started out that way and then have shifted to using us. And we see that adequate documentation of whatever the problem is, whatever the reason is that they're pursuing the eviction, is a common issue. They just don't have a paper trail for whether it's non-payment or some other lease violation. When it comes down to it, they don't have solid enough evidence to demonstrate that the tenant breached the lease and that they're entitled to the eviction. And sometimes it's more procedural hiccups, like just navigating the process of completing the court documents and filing it. And then Mitch mentioned this earlier, but significantly, all of the differences in the different counties. And we have two presenters that are going to be speaking specifically about the eviction process and sort of the evictions 101. We're starting off with that. That's going to be useful from brand new attorneys to those who have been practicing a long time. But we're also, as a panel, going to talk about how much things can vary depending on where you're practicing. And my colleague, Joe Andreoni, who's also on the panel, and I have been fortunate enough to appear in many counties and start to get a feel for, sometimes you don't know until you're there. You can't necessarily find it in a statute or a rule anywhere. You just have to learn the process. You have to get the lay of the land. And that's something that can be really daunting for pro se parties. And as attorneys, we're used to having to just figure it out as we go through the process.
Yeah, that's a great point. Professor Mitch, I was going to ask you kind of along similar lines. So what are some of the more common defenses that a tenant might raise during that eviction proceeding, and how might you advise attorneys to kind of help them prepare for it?
Yeah, the common defenses to an eviction and the preparation actually, they're going to come from documentation typically. And so whether that includes, so the thing to do and the thing that we'll emphasize and get into a lot more detail at the presentation about is making sure that you have the documents. That's the lease, that's any addenda, that's any communication between the parties. That's certainly notices leading up to any eviction. That's the eviction filing. Any affidavit of service type documents can be really, really key when it comes to defenses. So really careful collection of the right documentation, which is all of it, and then a careful review of the documentation to try to spot any potential defenses and raise them. Because while there are a lot of defenses, I think they're all essentially waived if they're not raised. And because evictions move so fast, they need to be reviewed quickly. You need to have those documents ready. You need to get them quickly and raise them quickly and counsel clients quickly as well. So it's a compressed time frame for those types of things.
Yeah, I'm kind of hearing a theme of communication and getting your documents in order and making sure that you're doing these things quickly. I think hopefully then anyone attending this session, that's going to be a really tactical thing that they can take back to their particular practice and help their clients with. So turning then to a little bit to negotiating stipulations and post-court actions. Mitch, maybe I'll go back to you. When you're doing that, when you're negotiating stipulations for tenants, what strategies help achieve sort of favorable outcomes, especially for habitability or payment plans?
Yeah, you've got to find common goals. At least as far as a strategy goes, that's a super useful one. Is to try to find common goals. Again, this is not a super adversarial, limited relationship. Again, I'll use the car accident example where, you don't know the insurance company that you're suing or you don't know the other driver. It's often an ongoing relationship. You mentioned habitability. We're going to spend a good chunk of time on that. The renter simply wants a safe, habitable place for themselves and their family to live. And I guarantee you that every owner wants a safe, habitable, up-to-code place to rent out and to make some money from, right? And so you have an aligned interest there. At the base of it, there is an aligned, shared, common interest. And so if you can get, and kind of push out some of the you didn't fix this, or some of the animosity that might have built up in an ongoing relationship and get to those shared goals, those common interests, that's going to work wonders in being able to come to a resolution that's mutually agreeable. And like I said, I'm not going to apologize for this. Respectful communication, obviously.
Well, then Jessica, kind of turning towards more the landlord side of things, how do you approach drafting stipulations to ensure enforceability and clarity during eviction hearings?
That's something that, again, it's a repeat theme of my answers is going to be how things can vary so much by county. So knowing how the court commissioner or the judge or the county that you're before approaches stipulations is one thing. So for example, in Dane County, if you reach a stipulation at the return date, the commissioner will write it up themselves. That's rare. Most counties don't do that. So again, it's more of a procedural technical thing, right? But communicating with the other side, which in my case is frequently with pro se tenants, before court if possible, or at that return date, or between the return date and the trial date that has been set, or whatever the case may be, about what result do they want? What result does everybody want? Can you find a common ground? Because it's not always super straightforward, especially if the eviction is not for non-payment. Oftentimes we'll have something where there are a lot of rule violations and the tenant needs to take a number of steps to fix the issue before the landlord would be comfortable with them staying. So we work out, well, what's a reasonable amount of time? Now that we have the eviction case filed, we have some leverage and we can maybe give a little more time. We can give them 3 weeks instead of a week, to replace the skirting on the manufactured home or something like that. But then also using that as an opportunity to address all issues that may be pending between the landlord and tenant. So for example, the eviction may be filed for non-payment, but in the interim, my client may have learned that there's an unauthorized occupant who hasn't been approved. And so I'll say to the tenant, oh, look, we also need to get your boyfriend approved. So let's do that too. Let's take care of everything now. We'll get the lease amended or get him added to the lease. And so approaching the stipulation or the negotiation stage as an opportunity to maybe clear up multiple things that are pending so that the parties just don't end up right back in court a couple months later.
Okay, yeah, those are great examples. Turning then to sort of fair housing and subsidized housing, Professor Mitch, what are the unique challenges that tenants with housing subsidies may face during evictions or post-tenancy claims?
Yeah, with subsidized housing, there are certainly going to be limited options for folks to find other housing, right? So often when there's a housing dispute, certainly in evictions, even ones that end with an agreement to remain, looking for other housing is certainly one of the things that you want to always be considering. And when you're limited in where you can go, that suddenly, it's such a limited market for public housing, and unfortunately a limited market for folks that take Section 8 benefits as well. So just being aware of those limitations, and then also realizing that there are extra interested entities. I want to kind of avoid calling them parties because they aren't always parties really to an action, but making sure that your local housing authority knows, making sure that the caseworker knows, because as folks may not realize, if you're receiving a Section 8 voucher, which is largely going to the property owner to cover rent, and you're going to move, you need to get sort of permission, and then you have a limited number of days in order to transfer that from one property to another. And you can get that extended once, but you need to get that extension sort of requested and asked for in writing in order to find subsequent housing. So again, being informed and aware of those limited options, knowing all about the other folks that you need to communicate with and keep informed, and really sort of participate in, potentially participate in the resolution in a way. So those are key unique aspects for folks in subsidized housing.
And so Jessica, then kind of along similar lines for landlords, how can they best navigate sort of some of the overlapping or possibly even contradictory requirements in state, federal, and local fair housing regulations?
Navigate is exactly the right word, Peter. It can be a lot. And when I'm either helping a client walk through it or maybe walking through it with another attorney, it is important to remember that you most frequently are dealing with local, state, and federal. There aren't always local regulations, right? You might be in a municipality that simply doesn't have any of its own fair housing regulations, but you're always going to be subject to state and federal, and it's important to keep that in mind. And um, just as in some other areas of law, employment law is a good example where it's very similar. You want to advise, the landlord or the employer. You need to be sure you're following the law that gives the most rights to the other party, right? So if there's ever going to be a conflict, you don't say, oh, well, I just follow Wisconsin because that's where I am. You want to err on the side of following what gives the most rights. And then also when it comes to actually dealing with fair housing complaints, it's important for attorneys getting into this area to know that it's quasi litigation. It's administrative litigation. You need to approach it like litigation, but you also need to approach it with, I think, probably a lot more practical mindset than traditional in-court litigation. And so that means taking advantage of mediation and conciliation that's offered early. That's not something, at least in state court here in Wisconsin, you're rarely going to do mediation, a week after the case is filed, right? You want to do discovery first. The Madison Equal Opportunities Commission here in Madison, who enforces the fair housing laws, they're great about offering that early conciliation. And my client will often, they'll be mad, that someone filed a fair housing complaint against them. I don't want to do that. Do I have to do that? And I'll say, well, you don't, but it's a really good idea to do so, because not only can it save you money, but we can actually figure out what the real problems are. Sometimes the fair housing complaint process is an opportunity to, again, open that door to something and then realize, hey, we can actually resolve a lot of what's going on here, even if it wasn't originally listed in the complaint. And it can be a way to foster communication between the landlord and the tenant and help them have a positive continuing relationship. So seeing it as not just litigation, but an opportunity for all of those things, I think is important.
Very good. So jumping over then to Jessica, something that's kind of I know is in your area of expertise is the manufactured home communities a little bit. What are some of the most significant challenges that landlords face in manufacturing home communities?
I would say the most significant challenge is that there are a number of differences between the rental of a site in a manufactured home community. So for starters, typically the tenants or residents own their homes and they're just renting the site, the plot of land. And oftentimes courts and agencies that we have to deal with aren't that familiar with those differences. And so it can be a challenge to navigate that and to sometimes explain to a judge or adjudicator, yes, they own their own home, but they're renting my land. So, here's how it works. And some of the differences, there are some specific leasing requirements that don't apply to other residential tenancies. So, knowing those from the get-go and then being able to explain them to adjudicators and others that are involved can be a challenge, and frankly is why I have a job, Peter, because there are so many nuances, and I'm educating someone new every single day about what they are.
Well, that yes. Well, we're happy you have the job, I guess, and it's also why a great part of this presentation that you'll be doing, that you'll be bringing some of that information, because it is something that is. It sounds like it's something that is very common. And so, Mitch, I was going to turn to you then. What kind of unique issues do you see that tenants face in manufactured home communities, especially with like lease renewals or utility charges or those kinds of things?
Jessica really mentioned this. It's extra unique. It is a Russian nesting doll, if you can use that metaphor of things, because we already have as we've mentioned, some unintuitive laws that govern rental housing. All of those apply, but inside that is a smaller subset of even more counterintuitive, not straightforward laws that apply to manufactured home communities, right? And then, and they're different. There's like one tiny one for people who rent the lot, and then a different one for people who rent both the home and the lot, and not the, both the home and the lot. And so knowing that nuance is really important. But to give you a really interesting specific example that unfortunately comes up too often, so manufactured home communities are a really important part of providing affordable housing. One of the ways that they do that is some economies of scale. So you'll have a lot of homes in a community. And some of the times those homes are connected on the same sort of utilities, water, sewer. And the sewer systems, when you have an entire community on, say, the same septic tank, that can run into needing to be serviced more often. And so that's a unique problem that, again, we see too often in manufactured home sort of scenarios where people don't realize that, because, again, it's kind of an exception to your ordinary rule. There's less control, like a homeowner who has to deal with a septic tank would normally take care of it themselves. But since you're owning just the home and not the stuff underneath, like that it's connected to, those utilities, it's a very unique relationship. And as you can imagine, if you don't manage it, well, then you got to manage something else.
That's a great point. I want to shift then to fee shifting claims. And, I never actually know, is it DATCP? Is that DATCP? Is that how you all typically refer to it?
DATCP.
DATCP? Okay.
Yeah, so we add an extra A in.
Yeah.
Pronounce the acronym.
Yeah. So this is something that you learn by coming to the session. So DATCP. So fee shifting claims and DATCP complaints. So Mitch, I wanted to ask you then, can you explain a little bit about how you leverage fee shifting provisions and DATCP complaints to help benefit tenants?
Yeah, I mean, the simple answer is that by having fee shifting, what the legislature did was incentivize attorneys to take cases, right? That's the only reason that you get in fee shifting is because the legislature and the department recognize that there's a lot of disputes, and there isn't enough manpower or, lawyer power, really, if you will, at the Department of Justice or at the Department of Consumer Protection to handle resolving all of those disputes. And so by authorizing fee shifting, you can incentivize attorneys to work on these cases. And what we actually see, again, and this seems, maybe a little counterintuitive, which is a shame, is that the incentive, getting an attorney involved for the renter can help get a resolution, right? Can help get a resolution sooner rather than later. And so that's the big way in which the fee shifting works to renters' advantages, is it takes a pool of essentially no attorneys who are going to take renters' cases. There's a small pool for anybody doing rental housing on either side, but basically it would be no one other than the legal services companies taking renters' cases. And by providing fee shifting, boy, I mean, you should come to the seminar, folks, if you're an attorney, because you can learn about how this can, in fact, be an important piece of a business, is helping people get to resolution, because you can actually work for somebody who cannot pay their rent, but you can get paid doing it. And so that's really important. This is just being able to bring an attorney to the table to point out some of these unique counterintuitive or regulations and surface those and get to resolution. So that's what's really important to get those better outcomes for everybody with fee shifting claims. And the thing, that I think people can look for if they're coming to the presentation, this is important, is that there are a lot of fee shifting claims that are mandatory. Now, sometimes we're educating court commissioners and judges about this, certainly educating other attorneys about this. Fee shifting in a lot of claims are mandatory. I'll say it again. But there are a lot of other claims where there's no fee shifting at all. And knowing the difference between those is really obviously very, very important. And that's one of the things that we'll cover is making sure that even though it's all rental housing, a quick example is that there's a retaliation law in the state statute and there's a retaliation law in the administrative code. And under one, you can get fees shifted, and under the other, you don't. So you could be bringing a retaliation claim, and you might or might not have fee shifting. Yeah.
Wow. Yeah. Good information to know. Jessica, what about from the landlord side? What kind of steps can they take to avoid some of the fee shifting claims or adverse DATCP complaints that could come up?
Yeah, I think it's important to, again, this sort of goes to the prevention and, knowing the laws and complying with the laws so that problems won't even arise, right? And, landlords and lawyers advising landlords obviously are well advised to know the DATCP regulations that apply. Chapter ATCP 134 applies to all residential tenancies, and then we have Chapter 125 that applies only to manufactured home communities. That inside that Russian nesting doll that Mitch mentioned. And it's important to understand the difference between a complaint that's filed with the administrative agency and an actionable claim that can be litigated in court, right? And the damages and the fee shifting come in with the court claim. However, the ability to pursue them is not mutually exclusive. And that's also something that a lot of landlords don't understand. You can and frequently do have both going on simultaneously. So you get a DATCP complaint, deal with it right away, respond, work with the investigator to get them the information they need. They're trying to figure out whether a violation of one of the regulations that they are charged with enforcing has occurred. Regardless of their finding, depending on the authorizing regulation or statute, that tenant may be able to file an action in court. And it may be, as Mitch mentioned, a mandatory fee shifting. And so, on both sides, understanding that early on helps you understand the economics, right, of litigating or resolving the matter. And I'll tell you, I'll be honest, I've settled more landlord-tenant matters than any other type of matter in my 21-year career because of the fee shifting. And but it's there for a reason, right? Tenants are entitled to representation and often can't afford the representation if there's not a fee shifting aspect to it, right? So I think that there's a reason that it's there, but it's also a very practical concern in approaching the matter early on. And are you going to spend tens of thousands of dollars to fight this, or can we probably resolve it? It really depends on the case, of course.
Yeah. That's a great point. Well, I know we're coming close to the end of my time here with you both, so I want to kind of quickly shift to the last few things on my list. Jessica, I was going to ask you, this deals with property condition and healthy housing. I wanted to ask you, how should landlords approach repair duties and respond to tenant claims of retaliatory or constructive evictions?
That's another thing where prevention is best, right? So, not only making sure your property is in good condition and habitable and up to code, but having a system in place for dealing with maintenance requests and tenant complaints. Too often, a landlord will come to me, whether it's because they're evicting or a complaint has been filed or they just want advice, and I'll say, okay, where's the documentation of the maintenance requests? How are tenants informed to make those requests? Oh, they just text me. They just call me. Well, okay, how about having a system? How about having an email address that all requests go to, or a line dedicated for that? Or, nowadays, a lot of especially larger landlords have tenant portals where they can make a request online. So having a system for those communications and for documenting them is really key, right? But then again, promptly addressing the issues, because if you have a tenant who has concerns about habitability, then you could be dealing with potential rent abatement. And so you want to address that sooner than later, not only to avoid a claim, but because, as Mitch said early on, and I agree with him, every property owner should want their property to be a safe place to live. And sometimes they may honestly not know of an issue, and then it comes up, and okay, let's address it. And then also another thing I'll add is the relationship element of working with your local building inspectors. So if the building inspector comes, whether because it's a scheduled or random inspection or due to a complaint, work with them, utilize them as experts. Tell me what I need to do and I'll do it. And pay attention to those deadlines. In smaller communities, it's going to be slightly less formal in terms of communications. Madison is a little more structured, but don't see them as the enemy. See them as someone who wants to help you provide a safe and healthy place for your tenants. I mean, everyone should want the same thing. So if you work together early on, you should be able to make that happen. And again, prevent it from turning into expensive litigation.
So Mitch, then I was going to turn that question kind of over to you. Are there strategies that you think that attorneys should really employ when advocating for tenants that are facing habitability issues, especially for things like abatement or retaliatory eviction claims?
Yeah, you got to communicate. A property owner cannot fix something they don't know about, to Jessica's point. And you got to have documentation of that. Jessica mentioned portals. Just a piece of advice to anyone and everyone, that I think this will come up at that presentation. Be careful about what portals you sign up for. We've seen plenty of them where a renter gets locked out, or like you turn off their account because they've decided to move out, but then neither side has access to that renter's account anymore. It's just gone because you don't own it. You've deleted it, or I don't know how this works. Because again, people just sort of outsource it and they think it's online, so that's great because that's where everything is. Jessica mentioned email. I'm a big fan of that. Both sides have a record. It's pretty hard to lose. Texts are not the best because so many people lose their phone and they whatever they download them, they can't seem to get them back. So email does work really, really well for keeping a communication record of requests, because you want that and you want your responses. Both sides, again, want to be able to say, hey, look, I asked for X on this date. Our maintenance guys said that told you they were going to come over, gave you notice, came over, tried this thing, asked you if that was okay. You said yes. Now you're suing, or you said no, but there was no follow up. That having that record of communication is absolutely essential, because there are some renters who are scared, rightfully so, of the retaliation aspect of asking for help. There are retaliation protections, as I mentioned, in state law and administrative law code, and then also some local regulations on it as well. So renters should feel comfortable reaching out, and because of the reasons that Jessica mentioned and I mentioned earlier, owners should be grateful. The first thing, and I say this as a rental property owner, the first thing that you should say when you get a phone call, even if it's on a Friday night that the furnace just broke and you were planning to go out of town yourself, the first thing that you should say to the renter who calls and says the furnace broke is thank you. I want to fix this. I don't want you, moving out into a hotel. I don't want you freezing to death for your family. I want to fix it. I want to make it right. Buckle down, realize that you're going to maybe have to adjust what the rents are going to be in order to afford a new furnace and an emergency weekend call. But this is the business that you chose to get into. And you should be grateful that your customers called you and didn't let the pipes freeze because they were afraid of retaliation. Right. So having that attitude of communication and gratitude in the rental housing relationship will solve a lot of problems. And attorneys, we talk about adversarials, but really we're a civil dispute resolution mechanism for folks. And so I hope that people can take that away from the rest of the presentation that we give is, even though we may see on the other side of the V or whatever you want to call it in court, being civil and respectful and communicating, will help out everybody.
Well, I think that's an a great place to leave the conversation about the update that we can, whether you are representing landlords or tenants, that we can come together and learn from each other. And this is a great venue for making that happen. I guess my last question to both of you is just, is there anything that you're really excited about when it comes to this, to presenting at this seminar? Anything I mean, you're taking time to volunteer to do this, and we're so grateful for that. What gets you excited about this?
I can go first. I'm excited. As Mitch mentioned earlier, we have an excellent panel of experts, and I personally know all but one of them, and I'm excited to get to know the one that I didn't previously know better. I love practicing law. I do it because I love it, and I love seeing other people that love it and are just passionate about it. And having worked with a number of other landlord-tenant practitioners, and there aren't a lot of us, so we do get to know each other. It's a small bar. I'm hoping that this update will help it grow a little, because I think we could use more people in this space. But I'm really excited to just be up there alongside people that are passionate. And I'm chairing and moderating this, so I expect that I'm going to have to cut people off sometimes, which will be a good thing because they are so into what they're teaching about and have so much to say, that I'll have to remind them that we do have a time limit. So.
Yeah, as Jessica just said, the great crew, and then the chance to share some of this information with folks, because of the sort of enjoyment of the practice, when you can help people, help families live in habitable, safe homes, and help people who own those, not have to deal with an involuntary move, a relocation. That's great. And just, again, the knowledge side of this. I have a case that I was working with a new opposing counsel that I have never worked with before. And I had to spend some extra time on the phone trying to politely sort of say, I don't think you realize that a couple of these things here that I think are sort of, you need to kind of look these things up. And it's hard not to come off condescending and because of the adversarial rule. So what's great is if I'm having that same conversation with Jessica or with somebody else that knows this area, anybody that attends this presentation, when we have that phone call is going to be like, oh, right, that, yep, okay. And we will save both of our clients so much more time. And we're going to get both of our clients such a quicker, better resolution because we've saved them time and because we know that law. And so I don't have to mansplain stuff to some new attorney. I'm sorry, but there's this unintuitive law. She probably just thinks I'm giving her a line. I'm not. Come to this presentation, and you'll help your clients out.
I just wanted to really quickly. I wanted to just ask you because. You're one of the authors for the Wisconsin Landlord and Tenant Manual, and first of all, just thank you for doing that, for sharing your expertise with other attorneys. I was kind of hoping you could just really quickly just kind of highlight why, first of all, why write for the State Bar of Wisconsin Pinnacle? Like what are you getting out of this that for you personally?
Yeah, well, writing a treatise is an honor, and that's what this is. This is a treatise on rental housing law. Every state is very different. Wisconsin is certainly unique. And so this is something that benefits everyone in the state of Wisconsin, not just lawyers, but, we've written it. Myself and the other co-authors have wrote it in a way that is accessible. It is certainly, geared towards a lawyer audience, but it's accessible enough that any property owner, should be able to pick it up and learn a lot of practical tips so they can avoid problems. And if they're avoiding, difficult situations, that's good for them. That's good for the renters. It's good for neighbors. It's good for communities. It's really a virtuous cycle of benefit to be able to share information and that helps people avoid worse problems.
Yeah, I actually didn't know until I kind of was looking into this discussion. I actually didn't know that the guide was written in a way that is more, the language is a little bit more applicable to anyone who can pick up this book. So that is really cool. I think that's something that's really helpful to just anybody who is, like you said, is a landlord, a tenant. Hopefully, if they have a legal issue, that they're using an attorney. But that's so it goes sometimes. Is there something about this book that really jumps out at you for attorneys that you think is really helpful for them as they, whether it's tenants or landlords, that can really help them sort of advocate for their clients?
Yeah, again, a lot of the practical aspects are highlighted in the book. The editors at Pinnacle did a really nice job of having, I think, what they call call outs or little indents, practice tips, and things like that sprinkled in. There's a lot of forms available. There's some examples available. More of those will be available at the presentation, right? So if you don't own the book, you should own the book. If you own the book, you still need to come to the presentation because it's an update after all. We're going to cover things that haven't been in there. We're going to take your feedback if you own the book. Someone actually just told me, hey, I got a great idea for an extra section. I'm going to talk to the Pinnacle folks and say, hey, we need to add this section. They're right. We didn't include this in the book, but it is one of the topics that we're covering at the update. So it's really useful that way, those practical tips, and again, the feedback that we can get to improve it. I'm really excited, to share that at the update. There's publication of cases does not happen often in rental housing law. That's because most rental housing cases are small claims, and almost all small claims, in fact, all small claims cases by rule are decided by one judge. So there's an exception. A motion has to be made for it to become a published 3-judge panel and for you to get a published decision. And so much of the law happens in a way that the legal developments and the decisions aren't published, and therefore, the local practice, not just a county's rule, but how courts, even at the appellate level, are deciding these cases if they go up on appeal is really important and is only going to be learned by, again, finding out who the practitioners are in rental housing and meeting them, talking with them, which you can do if you, read the manual. You can, contact the authors. You can do that, again, if you attend the update and meet a lot of great folks there.
Yeah, I love that. It's like they work in tandem, right? The manual supports the update supports the manual, that you can get a really well-rounded and updated experience in this area if you're attending it and using both. My last real question to you is just, is there, for attorneys who do want to stay on top of all of this shifting law and best practices and things like that, are there any of the resources that you would recommend attorneys use beyond the update or the manual?
So, it is a lot, the people, reaching out to one another, again, whether it's the authors, other folks that you meet, other practitioners, reaching out respectfully to county clerks to talk about just a procedural question. How does this work? Really, really concrete example of this that I use myself. In Dane County, if you file a small claims court action, that is not an eviction, a rent and damages type case or a case about a security deposit, the return date will be 28 days later, right? Because the statute gives the clerk discretion as to when to set that return date, but it is always 28 days later in Dane County. In Sauk County, it's different. In Rock County, it's different, right? And so knowing how many days you're going to have before an answer needs to be filed is a really very basic but hugely important piece of information to know. And so resources, to your question about resources, is knowing that you can, in fact, call a court clerk with a procedural question like that, because a lot of that is simply not written or available on the clerk of court's websites. Because, again, they might think, well, this is the way everybody does it. But in fact, from one county to the next, it's different. And that impacts when you can serve. It impacts, when you have to go to court, whether or not that return date is as mandatory in person or can be in writing can change from county to county as well. So really important to know and draw on local court clerks. Other practitioners would give you this answer as well if they're familiar enough with that county. But what I would do is I would always check myself because county rules could change.
Well, that's a great place to leave it. Thank you so much, both of you, for sharing some of the information. Obviously, it's a big topic, but that's why it's important to bring people together to learn from each other. And we're looking forward to being able to host you both at the upcoming Landlord-Tenant Law Update. So thank you so much.